Good evening, everyone. We're going to open the zoning board of appeals meeting. Howie Traster, Elaine Baker, Sue Noyes, Eric Stein, and Adam Costa, I'm sorry.
That's okay.
Town council. So we're going to start off with the original. Yep.
First up tonight is Richard White Jr. Continued hearing. The applicant is requesting a variance to allow a continued use of a detached accessory structure pursuant to Newbury bylaws 97-4D as the garage in a one-bedroom unit apartment on the lot property located at 10 Annapolis Way, Plum Island, Assessor's Map U020-98.
Is there anybody here representing Richard White?
I'm Richard White,
Okay, come on up then.
but my lawyer has not arrived yet.
Okay, so,
What do you want to do?
Could wait.
wait a little while? Okay,
Do you
we'll,
want to just recall it
we'll,
after we're done with the next one, I guess?
Yeah.
Or two?
Thank you.
okay, we'll do that.
And maybe if Capiloupo isn't here, you can decide whether or not you want to continue on his behalf
Right.
or not, maybe go to Sun and Tally and then we can go
Right.
back to White.
Okay, 8 minutes.
All right, number two, Stephen Capiloupo, continued hearing. The applicant is requesting a special permit for relief from section 97-10D of the Newbury zoning bylaws as the proposed detached accessory apartment requires a special permit for the lot property located at 40 Old Rowley Road, Assessor's Map R05-0-43.
So as I said, I didn't hear from Mr.
Right.
Capiloupo since our last meeting.
All right, we'll, want to continue it till later in the meeting, if he does show up? Or do you want to just,
Well, has he provided anything, because we had
has
asked.
he provided
No,
anything at all?
I've gotten nothing, have not heard from him at all since our last meeting. I don't know if you just want to recall it, or if you want to continue it, or.
Let's recall it, hopefully we can get it out of the way. Okay, so we'll go-
October 18th was the first hearing on that.
Right.
October, November, December, January, February, 5 times up.
No, I know, we'll just, hopefully, you'll come and we'll finish tonight, one way or another.
Next up is, we're going to skip.
Costas is continued,
Continued.
so Dorothy Street.
Dorothy Strait, continued hearing. The applicant is requesting a special permit for relief from section 97-10D2C of the Newbury zoning bylaws to create an accessory apartment which requires a special permit for the lot property located at 23 Old Pine Island Road, Assessor's Map R32-0-37.
Okay, Mark?
Yes,
Come on up.
Mark Griffin for Dorothy Strait. Had intended to come here tonight to withdraw the application, actually.
Okay.
But that was because she had gotten the building permit, and instead of having a detached accessory apartment, she decided to put it in the structure. However, the building permit, I've been told, has been recalled because it was issued in error. Accordingly, we will not ask for the withdrawal. We would like to ask for a continuance to the next hearing so I can speak to my client and find out what she would like to do with respect to the application.
Okay, does that sound good to everybody?
Yeah.
So, and we haven't received any
Right.
plans or updates or anything like that?
No, we knew that she was working to try to get the attached
Yeah.
apartment issued by right. And so when we got the building permit, we intended to withdraw this application.
Okay.
And now that we apparently don't have a building permit, we want to keep this in our back pocket just in case we want to go forward with it.
Sure.
When's the March meeting?
March 21st is the next meeting. Can you sign on behalf of the applicant for a
Yes.
continued hearing?
Need a motion or anything out here?
Yes.
Do we need a motion?
Yep.
Okay, we have a motion to continue.
I'll make a motion, we continue to the next meeting.
Second.
All in favor?
Aye.
Opposed? Motion passes.
Yep.
Thank you.
Thank you.
Just read it all again. No. All right, so next up is Richard White, continued hearing.
Recall?
It's a recall.
Oh, yeah, good morning, it's fine. I missed your exit twice. Come on. Oh, this one's different than the last one, okay. Again. I'm just gonna borrow this, I suppose. So, good evening, Jill Mann here on behalf of Rick White in connection with 10 Annapolis Way. The last time we had met, there was discussion about the fact that we're not entitled to get a use variance because you don't allow use variances in the town. So basically, we had relied then on our pleading in the alternative, which was to reverse the building inspector's decision. I am uncertain as to whether or not there was a conversation with the building inspector or not. I had
The
mentioned that
building
I...
inspector is here to speak.
Oh, wait.
Right behind you.
Right
Oh,
behind
I
us.
didn't even see you. You know what? You even said hi and I didn't see him. All right, good.
So,
So basically, what you had asked us to do though was to provide for you some information relative to the home, and I did that. I emailed over pictures of the plans that we were able to get from the original owner. And in addition, it's probably easier. So I was able to get the picture of the home, the garage. And then, this is actually the present way that it looks. Sorry, the plans were a mess that we had gotten. They had been in the man's basement, so they were just terrible. I got copies, but they were so terrible. This is the actual home. Well, I don't know, let's call it 2,300 square feet. And then here are copies of just all the plans. And then here's a copy of the garage. And as you can see, the garage second story this is the way it was always built. I mean, it isn't a storage space, it truly is, for lack of even if it, for anything, it's a living space, it's pretty clear. It's going to be used and occupied. These were the plans that they built under that were submitted.
okay, there's no floor plan.
I don't debate that.
So it shows no,
We can't find anything, but we do know that when it was done, it connected to water. The betterment is not a betterment for one property, but for 1.5. So something happened at the same exact time the permit was submitted for the building plan. We don't know what it was because you don't have the files. I know that the building inspector couldn't find anything either, and we had originally thought that maybe you were the building inspector under the plans, but what we have are the signatures and sign-offs from the prior building inspector. So I don't even know if you were involved or not. I don't know if you were, I mean, it's
Okay.
15 years ago. So I guess our point, okay, so I guess our point is that we believe that this particular home was quite possibly the subject of a legally issued permit. I shouldn't say home. The accessory apartment was the product of a legally issued, or maybe illegally issued, I don't know which, building permit, but nonetheless, the product of the building permit because the assessor immediately recognized it. Now, I'm not saying assessor's records control. It is kind of odd that in the year that it was built, the assessor recognized it as a two-family. It is pretty odd that when you have your betterment, and what I did do is I pulled all of the copies of the water connections. At that time, it doesn't really show well, and I can give you copies of them, just so you have it for your records. But the water connections for them, everybody can have a copy if they want. They're not all that telling, to be quite frank. They're, in my opinion, pretty difficult to even understand, just so they have for the record. At the time when you actually had the betterment and the installation, it was 2005. So even in 2005, they assessed him a betterment, Mr. Daubitz, of 1.5. So he's paying for an accessory apartment, and he always had since its inception. So it's kind of strange. And again, we can't find anything in your records because you don't have it. Then you'd also asked me, I believe it was the chair, I can't remember who asked me, but somebody asked me, to give information relative to how they advertised the particular property. So the particular property was advertised as a two-family. I just give you the Zillow listing, if you will. So the Zillow listing does in fact show it, second page, as a, again, I know that doesn't pertain to you, but it does say it's a two-family on Plum Island, that's how they advertised for it. And I did want to make sure I raised one point, well, actually it's kind of two. So there were abutters who spoke, and I appreciate the comments, and it's good that people come out and voice their opinions, especially when it's going to affect their land. But the point is this particular property has been used as a two-family. That unit, it isn't as if it's going to increase anything, because it is presently, up until 2 months ago, or 3 months ago? 3 months ago, used as a two-family. As far as there being issues relative to parking, this particular property has probably more parking than any neighbor around it. So if you look beneath the home, I give you a picture of this just so you can see it. Beneath the home, there are actually 2 parking spaces. On the property adjacent to the home, in front of the garage, under the garage, are probably, I don't know, anywhere from 6 to 8 additional parking spaces. There's no shortage of parking. This particular person isn't burdening the public way or any of the private ways, nor is it burdening any of the associated properties around it, because it has sufficient parking to handle anybody that could possibly come to the property.
Could you bring us any proof that, that was rented, other than?
Oh, yeah, do you have those, you know what?
What's that?
Do you have copies of those, yes. We have basically the assessor was issuing excise tax, excise tax
Property tax.
invoices. Yeah, so here they're. We aren't allowed to open them, obviously, so I can't do that, but there they are.
So who was this addressed to?
The guy who lived in the apartment above the garage.
And,
What is it?
It looks like an excise tax bill.
It is.
Yeah.
Oh, that's a tax
Yeah.
vehicle.
Right.
Yeah, I can't,
Yes.
but you have no receipts for rent, or the previous owner providing any documentation that he received rent for property?
I probably could have Dobbitts tell me when you see rent. but
Well,
this
telling us doesn't tell us anything.
Well, no, this is, there couldn't be anything more clear that somebody's being sent, this is not Mr. Dobbitts.
No.
Sean Mohammed, and he lives at 10 Annapolis Way. I mean, if you want me to give you,
What were the dates on that?
of course,
Just
I,
curious.
What's the postmark date on it?
That's what
yeah,
I'm
I got
saying.
to, let me look at it from far away. This is Feb 7, 2019. I don't know, this is just pre-sorted. I mean,
So
honestly,
this was this year.
yeah, the assessor's records, when we go back and look, I tried to get the excise tax records and I couldn't.
Okay.
I mean, I'm sure Mr. Dobbitts would give me a copy telling me it rents it, but I mean, that was who was the most recent tenant, was Mr. Muhammad.
Any questions for, anything?
Well, I guess we should just go back and review. I mean, this is,
Or do we want to hear from
Well,
Sam?
yeah, I
first,
just
or-
wanted to make sure we were done.
yeah,
Want to let Sam speak?
Sure.
Okay. So let the building inspector
Of course.
tell us what he knows, and then we'll go from there.
Thanks.
So, the first I became aware of this was actually the real estate listing, showing it was a two-family. The assessor brought it to my attention saying, you know, that how is there 2 units on this lot? So we looked into the building permits, found that the permit was issued for a garage with storage above. It was issued by my predecessor. I did do the inspections from the rough frame on. There's no occupancy certificate currently, and there's no second means of egress, which would indicate to me that it wasn't approved as a living unit. I brought this to Mr. Dobbitts' attention. He said he was gonna take care of it, and we have a new owner. two egresses is kind of your building code 101 for a dwelling unit. That alone, you know, makes me uncomfortable that, you know, if barring not finding any documentation, the occupancy certificate, the sign-offs, any plans, just that alone, you know, makes me know that this was not approved as a unit. The betterments, much like the assessors, they just went down, saw what they saw, and assessed and charged that betterment based on that. Mr. Dobbitts would have the opportunity to ask for a reduction in that betterment for a non-unit. He didn't, obviously, because he felt he had a unit here. But again, my records right now, the permit filled out by Mr. Dobbitts says garage only, or garage with storage above, something like that.
Yep.
That line, and, you know, again, we're lacking that occupancy certificate and a means of egress, which would, again, indicate to me that it was not properly inspected or issued the occupancy certificate for a second unit.
Thank you. Yep, go ahead.
So if you were doing the inspections, was it roughed out for plumbing and, I mean,
I
it's hearsay, but
Yeah, I don't
you don't recall?
remember, but I, you know,
Secondly, if we have the building permit, would we not have the occupancy permit attached to the building permit in the same location, or?
typically, yes. And again, barring us losing something, you know, my predecessor was not great at record keeping, which is why I think we're missing most of the plans and whatnot. I'd like to think I'm a little bit better at record keeping, but could it have been lost? Sure.
But it also wouldn't have been issued.
Right, with
Yeah.
a single egress, it would not have made it that far.
Do you have copies of all the sign-offs?
I think there was some on the card.
Installations.
Yeah, so we have,
That's,
a rough and final, so the permit card itself says construct a garage. The rough and final electric were done, and then rough framing and final by myself. So no indications of plumbing at that time, which if there was in there, I would not have signed a final without plumbing sign off as well.
okay.
And for these, when we have the site plan that just shows an outline of buildings, we have A3, we have A2, and we don't have A1. And so the whole floor plan for the primary residence is not there. The lower foundation plans are there. And then you get to the garage, you have framing plans, and you have a rough plan. So to say that the garage was built out with no walls, I would think that A1 would show the house with kitchens and baths and things built in it, but it's not here to.
Yeah, typically on here, you'd have your partition walls breaking it down as to whatever the floor plan is.
Right. Okay, thank you, Sam. Do you have any response to that?
No, I mean, like I said, we don't have any records, all we know is the plumbing's there. Most of the records aren't anywhere. The plans we got from Dobbitts. I mean, I guess our position is, you know, the unit exists. If the board doesn't reverse the building inspector's decision on the basis, not that he's wrong about anything he said, but basically on the basis of, yes, it is possible that it was actually allowed habitable space at the time.
Even though it didn't have a second egress?
And I know, but It has, in what they do have, they have one of those ladders that sticks out the window, I know. I don't know the answer to the questions, all I can say is in 2005, water was brought in, and so was sewer to it, so it's just strange that it all happened, and can I really explain it? No. Can Mr. Dobbitts explain it? No. And we tried to get in touch with the builder, we tried to get in touch with the architect, we couldn't,
No, I know you've tried.
Yeah,
Sounds like
we-
you've tried very hard.
we definitely do.
Okay. Any comments from the audience in favor, opposed, questions?
Oh, I would add that if we did have to add, obviously, a rear staircase, we would do that. That isn't an issue. We are not looking to avoid any kind of compliance issue.
We'll close the meeting and discuss.
Okay,
Okay,
so,
go ahead.
question for discussion and for Adam. The applicant is seeking a variance, and
Well, I think they already realize they can't get a variance
Yeah.
because of use.
so, that's my point.
So they want a reversal now of the building inspector's
Decision.
decision. So the variance is out
Okay.
of the question for.
True, and so is special permit, and so is binding, so that's what was going on,
Okay.
is that those avenues are out of the question.
Okay.
So in terms of where is our ability to overturn building inspector's decision in the bylaws in Massachusetts general?
Sure. So there's nothing in your bylaw that speaks specifically to the administrative function that you perform as a zoning board of appeals, acting on an administrative appeal. But there is authorization in the zoning act. So under general laws, chapter 40A, the zoning act, there is authority for your zoning board of appeals to essentially perform three functions. You act on special permit applications, sometimes findings. You act on variance applications. Both of those are relatively simple, at least in the sense that you've got standards either within the zoning act itself or within your bylaw. Variances is a three-part test. It's in the statute, it's in your bylaw. Special permits, there's a standard contained in Mass General laws, and then it's expanded upon in your bylaw with respect to the sorts of factors that you look to as to whether or not a special permit should issue. Your administrative appeal function is a bit different because you are truly sitting as an adjudicatory board, the same way that a court or other tribunal would sit, hear the facts. There's typically a petitioner, sometimes there's a respondent that presents the opposite side. In this case, the respondent is essentially the building inspector. You hear all the evidence, and then based upon that evidence, you make a determination as to whether or not the decision that's being challenged, here the building inspector's decision, was right or wrong. And in making that determination, there are no standards to guide you in the sense that there's not a three-part test or a five-part test. But the question is, did the building inspector get it wrong based upon the standards that are, the regulations that exist in your bylaw? So this particular applicant presented arguments in the alternative, one of which was a variance. It was determined, I understand, at the last meeting that a variance could not be sought because it would be a use variance, and you don't allow use variances in Newbury. So that's off the table, and so we're stuck with the administrative appeal. And so the burden on the applicant is to establish that the building inspector erred, got it wrong, by determining that this particular accessory apartment is unlawful, is not permitted. And so it's the burden of the applicant to present to you sufficient information to prove that point, that it pre-exists zoning, that somehow it was permitted by way of issuance of a permit. That's the sort of evidence that you need to make that determination.
People regularly submit assessor's cards, but we don't use the assessor's card to measure buildings or measure site or determine setbacks. So the information on there is separate, just as we don't deal with Concom and other boards' jurisdictions. Two, there is no drawing A1, but there are other drawings, so there is nothing to prove the original build-out and whether it actually did happen at the time. I think we've heard from some others that don't have the exact cases, but of people being hooked up as betterment being added to the properties, but that doesn't mean that that makes it legit at that time. Well,
We don't have an occupancy permit.
Yeah.
right, no occupancy permit. And the third point would be, I don't know where we would have the authority to allow or grant something that doesn't meet the basic building code.
Right.
Period. That's not our jurisdiction, and we're not, as with other people, sometimes they assume that if they receive a special permit or a finding, that it doesn't relate or carry other conditions or all-inclusive conditions with it. That was my third point.
Are we still talking about the record? Are we back on?
Well, we're on the record.
No,
This
I
is
meant-
between us.
Yeah. Oh, okay.
Go ahead, so if you.
No, I was just curious, that's all.
Those are my
So,
points.
you wanna, I agree with all your points.
And I guess to the,
And I guess also there's really no record of anybody living
Yeah, there's no rents,
There's
there's no
no-
lease, there's no, they didn't produce any of that stuff.
there. And if it's been in use as that for however many years, it should have been more than 2 mailings this month, in my opinion.
has there ever been a case on Plum Island of which there's an equal property or something at the same time, or period was also granted at the same time?
I'm not sure what you're asking.
What?
Well, if we're back in 2000, or before 2000, were people, are there any other accessory apartments that, I guess we just don't know about them? There's no precedent for this.
No, we
That's what I'm
don't.
saying.
There may be illegal apartments that we don't know about, but nothing, there was, no accessory apartment, zoning at that
That was
time.
allowed on Plum Island.
Allowed on Plum Island. Again,
It
with-
still isn't, yeah.
so. I would say that, if you wanna make a motion, we'll open up the meeting and vote on it.
I motion that we open up the meeting.
We'll open up the meeting.
Well, I think for the, I'd make a motion to deny the applicant for an administrative appeal based on the 4 following criteria. That there is no proof that the original documents whatsoever showed a build-out originally to show intent. That there was no occupancy permit to show that it was properly accepted and put into existence. There was no, it's not to code now to be an apartment, so it shouldn't be an apartment. And even if we did have proof of somebody that lived there, it's not predating zoning to make it grandfathered in any way. And the fact that it does have hookups to water and sewer is, you know, is there, and it's undeniable that that happened, but that doesn't, that wrong or that fact that that is there doesn't make it right because of the 4 other reasons.
Second,
Second.
all in favor?
Aye.
Opposed?
Thank you, appreciate your time.
Thank you. You might just want to call again.
Thanks, Sam. Read the same for you. All right, next up, the cottages at Plum Island LLC, 14 Plum Island Boulevard. Continued hearing. The applicant is requesting relief from section 94-7D of the Newbury zoning bylaws. Its proposed change of use and associated construction requires a finding to alter or extend a non-conforming use from an auto repair school to an accessory use structure and parking for the proposed restaurant on 2 Old Point Road for the lot property located at 8R Old Point Road, Plum Island, Assessor's Map U02-0-153. Should I read the second one in conjunction or?
Sure.
And with that, in tandem, is the Cottages Commercial LLC, 14 Plum Island Boulevard. Continuing hearing, the applicant is requesting relief from section 97-4D of the Newbury zoning bylaws as the proposed change of use and associated construction requires a finding to alter or extend a non-conforming use from a mixed-use auto sales/repair and residential to a restaurant use for the lot property located at 2 Old Point Road, Plum Island, Assessor's Map U02-0-154.
Mark?
Good evening.
Yeah.
So I was not present at the last meeting on this application, these applications. But I understood from my client and from the architect that town council had some input, and there were several things that we were asked to provide to the board. We're in the process of trying to do that. First of which is to give you successive evidence of the pre-existing non-conforming use on each of the lots. It takes a lot of research and it takes a lot of time, so our intent tonight was to ask for a continuance. But our continuation date is going to bring us out to March 21st. We think that our non-conforming use 2-year limitation expires in or around the 17th of March. Since town council is here, I'd like to pose the question as to whether by filing we've preserved our rights under those 2 years, or do we need to have some sort of tolling by the board?
3 years.
Please.
Sorry.
No, it's okay. So I guess I'm gonna sort of address the questions in reverse order.
Okay.
I don't know that the board would have the authority to affect any sort of tolling.
Okay,
Um,
tolling is,
So there's a provision that exists both in the zoning act again, and it's reiterated in your zoning bylaw, that a non-conforming use, you essentially lose the protection if for a period of 2 years or more, that use ceases to exist.
okay,
So if you've got a non-conforming commercial use in a district that only allows for residential use, and that is ongoing for a period of 50 years, if you discontinue it for a period of 2 consecutive years, you then can't revitalize or reinstate that use. So the concern, of course, is that the applicant believes it's coming up on the 2 years. It believes it made the filing before the expiration of the 2 years, but that 2 years will expire on what, March 21st, or?
We believe
In
it
advance of
right
that date.
around the 17th.
So there's no mechanism that exists either under the zoning act or your zoning bylaw where the board could, by making a finding or a ruling, somehow toll that period of time, pause it, or stay it. 2 years is 2 years. With that being said, I'm of the opinion, at least on the spot here, that the application to the board tolls that period of time. Because generally when a board is acting on an application that's before, you're looking to what existed at the time that the application was actually made to you. So I believe that by getting the application in, that's sufficient enough, so long as the board is proceeding expeditiously on that application, to freeze in time the circumstances as they existed on that date.
makes sense to me.
It's the same with building permits. You submit, the code changes, you've made your submission, they're acting on it. It takes time to do things.
It's a big enough issue where I wanted to have it clarified.
Right now, I don't blame you.
So,
I can't promise the court will agree with
I can promise you we don't want to be in court. And then, actually that was one of the things that was passed on to me from the architect. so maybe I didn't get all of the information filtered through to me as correctly as I would have hoped. So while I have your attention, and before I request the continuance, what sort of evidence will you accept with respect to evidence of non-conforming use in order to prove that we're entitled to that? And I'll give you an idea as to the kind of evidence that we're finding. It's business certificates, meeting minutes and votes of selectmen. We have some photos. We can get some witness statements. Those are the kind of things that
And
I
how
think.
far back do those date?
I was told that we needed to make by 1959.
Right.
Yeah.
So we're almost there.
Things like that be substantial. I know, I'm gonna ask you, Adam, that, and I don't know if you were part of it, but Lisa brought up, Bob Lobster, that they were required to, bring forth proof of use. The things that Mark is talking about, something similar to that, that was acceptable?
Yeah, so there's no real right or wrong answer to the question that's been asked. It's sort of a bulk of the evidence viewed as a whole, whether it satisfies you. Or the real challenge tends to be the continuity of the use. So remember, you've got to be mindful not only of the fact that the use needs to predate zoning, but it can't be discontinued for any period of 2 years or more. So the fact that you were able to provide a business certificate from 1958, but then you have no evidence of use again until 1978, you've got
Right.
a 20-year gap that would be sufficient. Right, but in terms of what gets provided, it can be a combination of things. It can be a combination of affidavits from first-hand knowledge stated under the pains and penalties of perjury. It can be records of the assessor. It can be business certificates, other filings with the town clerk's office, permits and approvals that might have issued from various land use boards. All that information on the whole, as long as it provides for that continuity, can be proper for consideration by the board.
Okay, thank you.
That's all I was gonna add, is if you had people speak on behalf of, that they'd have to be in like letter written form.
Yes.
They can come in and present it.
Well, we thought we'd probably have a sworn affidavit if we couldn't get somebody to show up personally.
Right, sure.
Yeah.
Okay.
And then finally, the issue of the parking, we're going to combine the lots
Okay.
prior to the next hearing, so to take that issue off the table. So it'd be all under one entity.
Made some progress.
Yeah.
We're getting there.
Yep.
Yep.
Okay.
So with all that, we request that the board continue each application to the next available meeting.
Okay.
Motion to continue.
Second?
All in favor?
Aye.
Opposed? Motion passes.
Thank you. Thank you. Thank you.
Which one?
Cemetery.
Richard and Susan Cementelli, continued hearing. The applicant is requesting a finding for relief from section 97-4D of the Newbury zoning bylaws, as the proposed construction will increase the height of the structure on the lot and exceed the lot coverage and FAR requirements of the Plum Island Overlay District, PIOD, on the lot property located at 952nd Street, Plum Island, Assessor's Map, U04-0-53.
Good morning.
I don't know if they have it, you also requested a copy of the current existing building.
Right.
You do have that.
I don't
The
have one.
existing building, I got these, Mr. Hughes dropped off this week, or last week, this week.
This is as built, so this
Right.
must be that. Okay. You have this?
Yes.
Yeah, okay.
I'm just looking to see if it was part of the original filing.
I don't believe
No,
it was.
it wasn't, that's why we asked
Yeah,
for it.
it was requested at the last meeting.
This isn't really an as-built, this is what you're proposing, isn't it?
That is the current,
Okay, so
the current.
probably an as-built is probably not the right reference, but this is what you're proposing with the measurements that you requested, I
Yeah.
think.
This is the new building.
Mhm.
Yeah, but we requested,
No,
No,
that's
this
the
is-
old
that's-
building.
This is the current cottage.
This is the old building?
Yes,
That's-
that's the cottage that's on the lot
Right.
now.
That's what I'm saying, so as
So-
built.
right.
Existing.
So have you made changes to,
On the plan that we had filed, we had, I guess one of the questions was, including the first floor deck in the far,
right,
and it's just a deck over a deck. And, the deck file with the plan would allow water through, there's also a stairway that's gonna go up to that. And, my builder had emailed, Mr. Jocelyn, also the building inspector, about whether this is included in the fire. He advised, I have the email here, and I spoke to him outside, that typically that, if water comes through
right,
the deck,
Mhm.
that would not
Then
be-
it's not
that would-
counted
that
as
would not
if
be
it-
included in the fire.
right.
So, I believe that the plan that we did submit, without that, those figures, it would be within compliance.
You could just condition it, that deck on the, enclose that.
Right.
That becomes an issue.
Okay. So, let's see. That was the calculation in the application for lot coverage.
The existing height of 1,286 square feet on a 458 square lot. I believe that's 27%. Which is the existing.
Right.
Twenty-one point seven.
And the proposed plan is 1,250, well, 56, it's about.
Well, you have 1256 on the application,
So
so how do we get
it
to
is
12?
smaller than the existing structure that's there now.
So we're taking the 264 square feet off from the last meeting.
For the FAI,
Yeah.
yeah.
you subtracting for the stairway, stairs?
You have 12,
There's 12
Yeah.
feet.
12 feet.
Well, let's just start with the lot coverage number, right? So we have the whole, everything that's covering counts.
Right.
So it's 28 plus 12 is 40, 40 times a width of 22 for the rectangle, 40 times 22 is 880. That's 880. So basic building footprint with the deck is 880. You add the small stairs, which is 22.5 square feet. You add the stair on the left, which is 41.5 square feet, and you come up with 944 square feet for total lot coverage on the first floor. There's nothing on the second floor that hangs over. So 944 divided by the lot size, 4550. Equals 20.74. So then we move on to the FAR. And for, just check to make sure I didn't write it up last time. The application says, so my last measurement was 1286, which made a lot coverage of 28.26%.
And that was including what we thought was a covered deck,
Yes.
so we need to,
And how about the bedrooms for quote unquote office? I had made a note that that was 81 square feet. Did you include that as well?
Yep. So, you can backtrack the deck off of this.
What? No, that's from previous. No, it wasn't.
so we have one bedroom existing, correct?
If my calculator's had it.
If you look at this one,
Yeah, hold on.
Plus the second floor.
No, they have 3 bedrooms existing.
Existing.
There's 3 bedrooms existing right now.
where are the other 2 bedrooms? We have one on the first floor,
Correct.
right?
The second floor is shown.
Well, it doesn't break it up, right?
Yeah, no,
So you have 2 bedrooms. Is that right? I mean,
well,
what you're saying is this is a bedroom, one bedroom on the
It's
second
it's
floor.
open.
Yeah.
With 4 beds in there, and then on the first floor, there's also a second floor.
Okay, 1, you can go to 2,
Right,
and 2,
wait a
you can
minute.
go to 3.
Right,
And that.
so,
so he says it's 2 bedrooms upstairs existing.
oh no,
Yeah,
you can't count that as 2 bedrooms. It's 1 bedroom,
well,
which means they can have 3 bedrooms.
yeah.
Because they have 2.
They have one on the first floor.
Yeah, this is proposed.
Oh, well, wherever it is, they have one on the first
Yeah.
floor,
Yeah.
and then
Second.
one on the second. And then there's three on the first floor, on the proposed, so
Yeah.
that's all right. Is the lot level?
Yes.
Okay, so what did you come up with for the second, the proposed FAI?
25.32. I take the rectangle of the building of 28 times
Yeah.
22, times it twice, and remove stair, have to stair 2 levels, I get 1148, 1150.
Okay. So, the application actually isn't correct anyway. The percentage.
So, rough
Okay,
that.
so you think?
My numbers could be off, geez. That's the total square footage I came up with less, so it's 1296. But,
And that's removing the deck?
yeah.
Yeah.
But they have 1296, then deduct the stairs.
What do you have for the FAI? Or the total square footage? that you have?
Total square footage, 1,190.
So how far off is that?
How
from
much? Yeah, it's a difference of, I'll defer to him, he's the architect, but.
Well, Eric's trying to figure this out. Does anybody want to speak in favor?
We have a couple of questions.
Oh, sure.
We're the owners of 752nd Street.
Could you give Susan
They're
name,
breaking
please?
I
What's
just
your last name?
Could you give,
Doolin, Doolan, I'm Sheila and that's Richard. That's 752nd Street. So your diagrams are a lot bigger than mine. I
yeah,
was
you're
just-
welcome to look at
okay,
anything
I
here
just-
you want.
I just wanted to clarify that from our property line, it said 10 and a half. And I wanna make sure that was from the porch and not the wall of the building.
Okay, so we're gonna go to,
Let's see.
okay, so you're over here or over here? Okay, so.
Okay, so it's a 10.5, like it's 10.5 from the porch or from the wall of the house?
From the porch,
From the porch.
stairway.
Okay.
Right.
Okay. And then the other question is, I don't really understand the whole information about the height. Is it just, a math formula or so many
Yes.
square feet and then the height?
No. It's 35 feet at the mean point of the highest roof. So if you,
Yeah.
yeah. I'll show you. Okay, so this is the mean of the highest roof.
Mhm.
It's 35 feet to there.
Okay.
That's the maximum. So the roof will actually be 40-something, I mean the peak. But the zoning bylaw on all houses in the whole town at 35 feet to the mean
Great.
grade from the,
So all the calculations you were doing is just making sure that that's in compliance
yeah,
with what it is?
that's pretty simple
Mhm.
to see on the
Okay.
plan. And the calculations that Eric is doing is the lot coverage, which is gonna be the same as it was previously, and then the FAR, which is the actual living space,
Mhm.
which needs to be either less than what they had before and hopefully at 25% of the lot.
Mhm.
Okay, does that make sense to you?
Yeah.
Okay. So if the figures come out right, it looks like they do comply,
Mhm.
you know, with the size and the height.
Okay, and
Okay.
we're very happy, you've got
Right.
this beautiful house.
Thanks for
We just had a
We-
tiny
we were
house
just
that's not gonna
concerned,
get bigger
no,
anytime
sure.
soon, because
More
we're on
water.
a skyscraper right next to us, so.
Yeah.
All right, so it looks
Right.
good.
Okay.
Thank you. All right, it's a little correction.
Okay.
So the second floor actually overextends the deck on the first floor. So first floor is smaller, the second floor is bigger.
Okay, yeah.
So the second floor is bigger, which technically means that this is covered that much of the deck. And so the FA lot coverage is slightly larger than previously noted. And to the FAR, is a little bit bigger than noted. So instead of just, I didn't add up every number on the sheet to confirm the room by room, but I just took a block, looking more closely at the plan and going back to the calculation. So, on the application, it's listed as 1256, taking out half the stair for the measurements of the first and second floor, I come up to 1278, so I'm right at about 28% FAR
On the new.
on the new.
And what were we, on the old, did we decide?
Existing.
Existing.
1286.
That's the total square footage, right? So, 1280.
1256 is what they put on the application, but I don't know what the numbers were.
Right.
On the application, they've got 1256,
Yeah.
but
For existing.
no, for the proposed.
Yes. Right here, and existing was 1286.
And that big cat list they're talking about,
Yep.
it was at 156.
Right.
Yeah, that's what we're trying to do.
And the proposed is 1256, but according
It
to
says
the
it's
application.
1278. Right?
I said it's 1278, right?
Yeah.
So it's going from 28.22% to 28%.
Yeah. It didn't increase at least. Okay. So I just want to make sure, because the numbers I have are incorrect. The,
Are you gonna mark up that application, so I'll have that on file, Rick?
Right, so this. And I said the lot coverage was. Right at 20.74.
went from, 27.74, slightly less, and very slightly less, but no larger. The height is okay. The setbacks are better, correct?
Yeah.
They all conform now?
This was site plan.
Yeah, 10.5, 10.5, 18 in the back,
Right,
and
20,
30 feet in the front. 30 feet, 25 feet to the stairs. The stairs are setback from the road to the front of there.
So they're all in compliance.
They're all in compliance.
Do you have any other questions about the project?
No.
You have any questions about the project?
No.
Okay. We have a motion.
A little more discussion, maybe?
Well, if you want more discussion.
Well, I guess with the application and understanding that you have a, basically, I guess the premise is that you have a house of a certain size and you're rebuilding a house that's almost exactly the same size, but it's ever so slightly less in terms of FAR and lot coverage. And in terms of trying to meet the terms of the PIOD, it's 20% for the lot coverage and 25% for the FAR. So you were over on both before and you're still over. And then in terms of the size of the home, you know, it's
Pretty much identical.
pretty much identical.
Right.
So in terms of betterment or improving the neighborhood or keeping the status quo, that's where we're at.
Right. I can't say that they improved the FAR or the lot coverage, but they did improve the setbacks. And it's probably a better house than what's existing.
Well, that's a lot better. It's starting to do something with this.
Yeah, so the rear setback was 7.8 and the side setback was 9.7. So it only netted on two sides.
So, in my opinion, they've corrected some of the problems, not all of them.
Okay. Okay.
Can I make a motion?
Sure. I'll propose to grant the applicant a finding for relief from section 97-4D on the basis that the application as presented is not, is deemed not more detrimental, sorry, the application as presented is deemed to be by the board to be substantially, to be not substantially more detrimental than the existing non-conforming structure to the area, and will be an improvement to the neighborhood with the improved rear and side setbacks, and no increase in the FAR or the lot coverage.
Second?
They're stated-
Second.
Yes.
All in favor?
Aye.
Aye.
Opposed? Motion passes.
Thank you.
Okay, you're aware of the appeals process, and where we go from here?
I'll go over that with you
Okay.
when I write it out.
So,
I'll give you a call.
one, we need a corrected application that you should initial and you should initial, so we have something for the record.
So this is what we're gonna use?
Yeah, every right, I get a copy of this.
Yeah, they'll be actually part of the recording.
Okay.
So,
Would you like
Okay,
site plan in here?
Thanks.
That, waste of paper, you can make use of it.
Okay, you need to, initial changes aren't made as far as the FAR and lot coverage. Just initial. Okay. And, so we'll be in touch with you. Okay, do you have any other business?
you just probably wanna read
Yeah.
all
I want
the
the cut.
Oh, so,
So let's hope you're,
Mr. Campbell,
These are my
so we would call.
Folks, would you mind, folks, excuse me, sorry, would you mind going just outside the door, because we're holding something? I can kind of tell you that I spoke with the board of health after our meeting, because he seemed to be a little bit confused about what direction he was put in. The board of health indicated to me that when he came to talk to them, and we're talking about the septic, he just conceded and said, I'm just gonna make the changes that I need to the bedroom in the accessory structure. it's just a lot easier for me to do that, so that you can even get into that conversation. And last I recall our meeting was about these.
He seemed confused about it all, and we gave him the direction to follow the steps of the bylaw and come back
Right,
with, you know, an indication that that's what he was gonna do.
so,
And, you know,
Septic and electric were the two.
Yeah,
yeah, the two biggest things, and there was, you know, as far as the bedroom with the septic, which really is the Board of Health. So, no matter what we ask him to do, he's not here. So, what would you like to do? We've continued this since probably October.
yeah, and he has not gotten an occupancy on the primary structure yet, waiting this decision as well, just as a point of information.
Who's not living there?
He's living there, but he hasn't gotten an occupancy.
So,
so he's living in the new structure.
So I think we have to give him some notification that he needs to show up with the information and plan and move this along. And we can't.
Yeah, or they have to issue a cease and desist.
so can we tell him that he needs to be here at the next meeting with all the correct information, or we're gonna put it to a vote?
Okay.
I mean, that's something we can do.
Yes, I think we can.
Okay, so I make a motion, oh, I'm not gonna make the motion, you're gonna make the motion.
I will make a motion that we continue this to the next meeting in March, that we notify the applicant that he must, you used the phrase that you just used.
I don't know what it
With
is.
all the information that.
Provide the information that's
required.
been requested.
Requested, or we're gonna bring it to a vote. With or without it.
And if he doesn't, then we'll ask them as a cease and desist issue.
No, we don't have a motion on his application, and that's separate.
Well, I know, but, yeah, okay.
Okay. We have,
Is that clear?
Second,
is it clear?
yeah,
Nobody else is gonna be clear unless you write it. All in favor?
I,
Opposed, motion passes. Okay, I have a motion to close the meeting.
motion to close the meeting.
Seconded.
All in favor?
Aye.
Aye.
Opposed, motion passes.